Hello, this is Ron Climer. I'm back for the second session of reading the comments from the North Carolina Real Estate Commission Rules and Laws. This is Appendix A in this textbook. So if this is your textbook, I'm reading from page 618. Now as time goes by, the textbook will probably change and so on, but I'm reading about misrepresentation or omission. It says misrepresentation or omission of a material fact by a licensee is prohibited, and this prohibition includes both willful and negligent acts. A willful act is one that is done intentionally and deliberately, while a negligent act is one that is done unintentionally. A misrepresentation is communicating false information, while an omission is failing to provide the disclosure information where there is a duty to provide or disclose such information. Material facts. For purposes of applying GS 93, whether a fact is material depends on the facts and circumstances of a particular transaction and the application of statutory and/or case law. The Commission has historically interpreted material facts under the real estate license law to include at least facts about the property itself, such as structural defects or defective mechanical system. Facts relating directly to the property, such as pending zoning change or planned highway construction in the immediate vicinity. And facts relating directly to the ability of the agent's principal to complete the transaction, such as a pending foreclosure sale. Regardless of which party in a transaction a real estate agent represents, the facts described below must be disclosed to both the agent's principal and the third parties the agent deals with on the principal's behalf. In addition, an agent has a duty to disclose to his or her principal any information that may affect the principal's rights and interests or influence the principal's decision in the transaction. Death or serious illness of a previous occupant. Note that GS 39 through 50 and 42 specifically provide the fact that a property was occupied by a person who died or had serious illness while was occupying the property is not a material fact. Thus, agents do not need to voluntarily disclose such a fact. If a prospective buyer or tenant specifically asks about such a matter, the agent may either decline to answer or respond honestly. If, however, the prospective buyer or tenant inquires as to whether the previous owner or occupant had AIDS, the agent is prohibited by fair housing laws from answering such an inquiry because persons with AIDS are considered to be handicapped under the fair housing laws, and disclosure of this information may have the effect of discriminating against the property owner based on the handicapping condition. Convicted sex offender occupying, having occupied, or residing near a property. Note also that the same North Carolina statutes state that the death or serious illness of a previous occupant of a property is not a material fact in a real estate transaction. Contained a similar provision relating to a convicted sex offenders. The statute provides that when offering a property for sale, rent, or lease, it shall not be a material fact that a person convicted of any crime for which registration is required by Article 27 of the General Statutes, those are the statutes establishing registration programs for sex offenders and sexually violent predators, occupied, or resides near the property, provided, however, that no seller or landlord or lessor may knowingly make a false statement regarding such fact. Therefore, an agent involved in a transaction is not required to volunteer to a prospective buyer or tenant any information about registered sex offenders as described above. If a buyer or tenant specifically asks about sex offenders in a neighborhood, an agent need only answer truthfully to the best of his or her knowledge. In the absence of a specific inquiry about the matter from the buyer, an agent representing the buyer who knows, for example, that a registered sex offender lives in the immediate area will probably want to disclose that information in the interest of serving his or her buyer client, even though not required by law to do so. On the other hand, In the absence of a specific inquiry by the buyer, if an agent who knows such information represents the seller, the agent will probably want to check with his or her seller client before disclosing that information, since voluntary disclosure is likely not in the seller's best interest. Any agent also has an option of advising a prospective buyer or tenant about how to check the statewide sex offender registry at the appropriate website. This introductory information should assist in understanding GS 93, which establishes 4 separate, although closely related, categories of conduct which are prohibited. They are discussed below, and a few examples of prohibited conduct are provided for each category. Willful misrepresentation. This occurs when a licensee who has actual knowledge of a material fact deliberately misinforms a buyer, seller, tenant, or landlord concerning such fact. A misrepresentation is also considered to be willful when a licensee who does not have actual knowledge of a matter material to the transaction provides incorrect information concerning such matter to a buyer, seller, tenant, or landlord without regard for the actual truth of the matter, i.e., when a licensee intentionally provides information without knowing whether it's true and the information provided is in fact not true. Note, the following examples of willful misrepresentation apply regardless of the licensee's status, seller's agent or buyer's agent, or role, listing agent or selling agent. Example, an agent knows that a listed house has a severe problem with water intrusion in the crawl space during heavy rains. In response to a question from a prospective buyer who is being shown the house during dry weather, the agent states that there's no water drainage problem. Example, an agent knows that the heat pump at a listed house does not function properly, but tells a prospective buyer that all mechanical systems and appliances are in good condition. Example, an agent knows that the appropriate market value of a house is $225,000, but tells the property owner that the house is worth $250,000 in order to obtain a listing. Example, an agent is completely unfamiliar with the features or condition of a listed property. However, the agent informs a buyer that the plumbing is in good working order without first checking with the owner. The agent in such instance is acting without regard for the truth of the matter being represented. If the plumbing in fact needs significant repair, when the agent may be guilty of willful misrepresentation. Example, without checking with the owner, an agent tells the buyer of a listed house that heating and cooling costs are very reasonable. Because the agent acted without regard for the truth of the matter, he may be guilty of willful misrepresentation if the heating and cooling costs are in fact extraordinarily high. Negligent misrepresentation. This occurs when a licensee unintentionally misinforms a buyer, seller, tenant, or landlord concerning a material fact, either because the licensee does not have actual knowledge of the fact, or because the licensee has incorrect information, or because of mistake by the licensee. If a reasonable, prudent licensee should reasonably have known the truth of the matter that was misrepresented, when the licensee may be guilty of negligent misrepresentation, even though the licensee was acting in good faith. Negligent misrepresentation by real estate licensees occurs frequently in real estate transactions. A very common situation is the recording of incorrect information about a property in the MLS listing due to the negligence of the listing agent. When a prospective buyer is subsequently provided the incorrect information from the MLS by the agent working with the buyer, a negligent misrepresentation by the listing agent occurs. A listing agent is generally held to a higher standard with regard to negligent misrepresentation of material facts about a listed property to a buyer than is a selling agent who is acting as the seller's subagent. This is because the listing agent is in the best position to ascertain facts about the property. 2, the listing agent is expected to make reasonable steps to assure that the property data including the listing is correct. And 3, it is generally considered reasonable for a selling agent to rely on the accuracy of the listing data, except in those situations where it should be obvious to a reasonably prudent agent that the listing information is incorrect. However, a buyer's agent may in some cases be held to a higher standard than a seller's subagent because of the buyer's agency duties to the buyer under the laws of agency and the buyer's agent's special knowledge of the buyer's particular situation and needs. Example, an agent has previously sold several lots in the subdivision under development, and all those lots passed a soil suitability test for an on-site septic system. The agent then sells lot number 35 without checking as to whether this lot satisfies the soil test. However, the agent informs the buyer that lot 35 will support an on-site septic system, when in fact the contrary is true. While the agent's conduct may not rise to the level of willful disregard for the truth of the matter, the agent was at least negligent in not checking the soil test result for lot number 35, and is therefore guilty of negligent misrepresentation. This result is not affected by the agent's agency status or role in the transaction. Example, an owner tells a listing agent with ABC Realty that his house has 1,850 heated square feet. Without verifying the square footage, the agent records 1,850 square feet on the listing form and in the listing information published in the local MLS. The house is subsequently sold by a sales agent with XYZ Realty, who tells the buyer that according to the MLS data, the house has 1,850 square feet. The buyer later discovers that the house actually has only 1,750 square feet. In this situation, the listing agent did not make a direct misrepresentation to the buyer. However, he initiated a chain of communication which led to the buyer being misinformed and thus indirectly misrepresented a material fact. Further, the listing agent's failure to verify the square footage constituted negligence. Therefore, the listing agent is guilty of a negligent misrepresentation. Although the selling agent directly communicated the incorrect information to the buyer, he probably acted reasonably in relying on the data in the MLS. In this case, if the selling agent had no reason to doubt the MLS data, the selling agent is not guilty of a negligent misrepresentation. Note, however, if the square footage discrepancy had been significantly large, that a reasonably prudent agent would have known the listed data was incorrect, then the selling agent would have been guilty of negligent misrepresentation. The result in this particular example is not affected by the selling agent's agency status, seller, subagent, or buyer agent, although this might be a factor in other situations. Willful omission. This occurs when a licensee has actual knowledge of a material fact and the duty to disclose such fact to a buyer, seller, tenant, or landlord, but deliberately fails to disclose this fact. Example, an agent knows that a zoning change is pending that would adversely affect the value of the listed property, but fails to disclose such information to a prospective buyer. The agent has committed a willful omission regardless of the agency status or rule in this transaction. Note, information about a zoning change, planned major highway, or similar matter that would significantly enhance the value of the seller's property must also be disclosed to the seller, even if the licensee is a buyer's agent. Example, an agent knows that the city has just decided to extend water and sewer lines to a subdivision that's been plagued for years by serious water quality and sewage disposal problems. This will result in a substantial increase in the value of homes in the subdivision. The agent who is working with the buyer to purchase a house in the subdivision does not inform the seller of the city's recent decision. The agent has committed a willful omission, and this result is not affected by the agent's agency status or role in the transaction. Example, an agent knows that a listed house has a major defect, crumbling foundation, no insulation, malfunctioning septic tank, leaking roof, termite infestation, or some other problem, but fails to disclose such information to a buyer. The agent has committed a willful omission, and the result is not affected by the agent's agency status or role in the transaction. Example, a selling agent working with a buyer as a subagent of the seller learns that the buyer is willing to pay more than the price of the buyer's offer, but fails to disclose this information to the seller or listing agent when preparing the offer. The selling agent has committed a willful omission. If, however, the selling agent were acting as a buyer's agent, then the result would be different because the agent does not represent the seller and has a duty not to disclose to the seller confidential buyer information that would be harmful to the buyer's interest. Example: a buyer's agent becomes aware that the seller with whom the buyer is negotiating is under pressure to sell quickly and may accept much less than the listing price. Believing such information should always be kept confidential, the buyer's agent does not provide the buyer with this information. The buyer's agent is guilty of willful omission. An agent must disclose to his or her principal any information would affect the principal's duty in this transaction. Example: suppose in the immediately preceding example that the seller's property is listed with the firm of the buyer's agent and the firm's policy is to practice traditional dual agency in in-house transactions, where it represents both the seller and the buyer. In this situation, the buyer's agent would not be considered to have committed a willful omission under the license law by not disclosing this information about the seller's personal situation to the buyer. Note, this assumes, however, that the buyer's agency properly disclosed his or her status as a buyer's agent to the seller or seller's agent upon initial contact. That dual agency was properly authorized by both the seller and the buyer prior to showing the seller's property to the buyer. The authorization was timely reduced. The authorization was timely reduced to writing in the agency agreement that also limits the disclosure of information in dual agency situation, as is the case with the agency agreement forms provided by the North Carolina Association of Realtors for use by its members. Negligent omission. This occurs when a licensee does not have actual knowledge of a material fact and subsequently does not disclose the fact, but a rational, prudent licensee should reasonably have known of such fact. In this case, the licensee may be guilty of negligent omission if he fails to disclose the fact to a buyer, seller, tenant, or landlord, even though the licensee acted in good faith in the transaction. The prohibition against negligent omission creates a duty to discover and disclose material facts which a reasonable, prudent licensee would typically have discovered in the course of the transaction. A listing agent is typically in a much better position than a selling agent to discover material facts relating to a listed property, and thus will be held to a higher standard than a selling agent acting as a seller's subagent. On the other hand, a buyer's agent in some circumstances may be held to a higher standard than a seller's subagent because of the buyer's agent's duty to the buyer under the law of agency, particularly if the buyer's agent is aware of a buyer's special needs with regard to a property. Again, we see how the agency relationship between agents and principals to a transaction and the licensee's role in the transaction can affect the licensee's duties and responsibility under the license law. Instances of neglect, omission occur less frequently than instances of negligent misrepresentation. This is because most facts about a listed property are recorded on a detailed property data sheet from which information is taken for inclusion in MLS listings. If incorrect information taken from an MLS listing is passed on to a prospective purchaser, then a misrepresentation rather than omission has occurred. Nevertheless, there are examples of negligent omissions which can be cited. Example: a listing agent lists a house for sale located adjacent to a street that's about to be widened into a major thoroughfare. The thoroughfare project has been controversial and highly publicized. The city recently finalized its decision to proceed with the project, and the plans for the street widening are recorded in the city planner's office. A buyer working with a selling agent makes an offer to buy the house. The listing agent does not disclose the street widening plans to the buyer or selling agent and claims later that he was not aware of the plans. In this situation, both the listing and selling agents are probably guilty of negligent omission because each should reasonably have known of the street widening plans, clearly a material fact that should have been disclosed this fact to the buyer. This result is not affected by whether the selling agent is a buyer's agent or seller's subagent. Example: A seller has a 30,000 square foot commercial property for sale which cannot be expanded under local zoning laws. The buyer is looking for property in the 25 to 30 square foot range, but has told his buyer agent that he needs a property where he can expand to 50,000 square feet or more in the future. The seller does not think to advise the buyer's agent that the property cannot be expanded, and the buyer's agent makes no inquiry about it, although he is aware of the buyer's special needs. If the buyer purchased the property without knowing about the restriction on expansion, the buyer's agent is guilty of a negligent omission and failing to discover and disclose a special circumstance that the agent knew was especially important to his client. Example: when a listing agent is told by the seller that one area of the roof leaks badly when it rains, but the moisture so far is being contained in the attic. The listing agent forgets to note this on the MLS data sheet and forgets to disclose the leaking roof problem to prospective buyers and selling agents. The listing agent is guilty of a negligent omission because the agent's failure to disclose the leaking roof problem was unintentional, and the listing agent is not guilty of a willful omission. However, his or her forgetfulness resulting in his or her failure to disclose the defect constitutes a negligent omission. Let's take a break.